So we are now in Rule 113, arrest. So we have initially discussed few principles for this rule last meeting. Okay. So again, definition of arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. So arrest ordinarily takes place after the conduct of preliminary investigation, except when the arrest is pursuant to a lawful warrantless arrest, wherein there is no need to conduct a preliminary investigation unless the respondent asks for the preliminary investigation, provided the respondent will waive his right under Article 125 of the Revised Penal Code. But ordinarily, the arrest of the person sought to be charged for the commission of an offense usually happens after the conduct of preliminary investigation. So the proceeding for the issuance of warrant of arrest is what we call as the preliminary examination conducted by the judge. Again, one important reason why there should be a warrant of arrest, or why is it that the respondent should be arrested, is that remember the requisites for the court the requisites for criminal jurisdiction. One of the requisites is the jurisdiction over the person of the accused. Again, the case will not proceed unless the accused is arrested, because that is one of the means of acquiring jurisdiction over his person, aside from voluntary submission. If the accused will not voluntarily submit to the jurisdiction of the court, there is a necessity of arresting him in order to acquire jurisdiction over his person. Remember that principle requirement for jurisdiction. Now, what are the requisites for the issuance of a warrant of arrest? The requisites are provided for under Section 2 of Article 3 of the Constitution, or the Bill of Rights. As provided therein, no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by the judge after examination under oath or affirmation of the complainant and the witnesses he may produce, and particularly describing the place to be searched and the persons or things to be seized. We discussed in our previous class that it is not required for the judge to personally examine the complainant and the witnesses. It doesn't mean that the judge should call the complainant and the witnesses to the witness stand. Okay, so what is required is that the judge will personally evaluate the report and the supporting documents submitted by the fiscal regarding the existence of probable cause, and on the basis thereof, issue a warrant of arrest. Or if on the basis thereof he finds no probable cause, he may disregard the fiscal's report and require the submission of supporting affidavits of witnesses to aid him in arriving at a conclusion as to the existence of probable cause. What is required is that the judge should satisfy himself that there really exists probable cause for the issuance of a warrant of arrest. It means there must be personal determination by the judge. Ibig sabihin lang is that the judge should not rely solely on the reports and the supporting documents submitted by the fiscal. He should make his own personal evaluation, personal examination of the records. So the line or the provision of Section 2 should not be interpreted literally, no, na the judge should call on the complainant and the witnesses to the witness stand. No? In fact, there is a case decided by the Supreme Court, no, wherein the court here, the judge here, dismissed the complaint on the ground that the complainant and the witnesses refuse to take the witness stand. So the Supreme Court held that the judge committed a grave abuse of discretion for dismissing the criminal case on the ground that petitioner and her witnesses failed to comply with his orders to take the witness stand. Because again, it is not mandatory for the judge to personally examine the complainant and the witnesses. What is required again is that the judge should satisfy himself by personally evaluating the records and the supporting documents submitted to him by the fiscal. So arrest how made? Section 2. An arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. No violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subject to a greater restraint than is necessary for his detention. So I have already explained this particular provision in our previous meeting. Duty of the arresting officer, again under Section 3, it shall be the duty of the officer executing the warrant to arrest the accused and to deliver him to the nearest police station or jail without unnecessary delay. Section 4, execution of warrant. The head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. So within 10 days after the expiration of the period, the officer whom it was assigned for execution shall make a report to the judge who issued the warrant. In case of his failure to execute the warrant, he shall state the reasons therefor. So these provisions are self-explanatory. Time of making arrest. An arrest may be made on any day, at any time of the day or night. So take note of Section 6 because we will distinguish this with search warrant. Time of executing search warrant. So in arrest, you can execute it at any time of the day or night. And on any day, provided within 10 days. 10 days from the receipt of the warrant of arrest by the officer assigned to execute the warrant. Methods of arrest with warrant. Okay. Section 7. When making an arrest by virtue of a warrant, the officer shall inform the person to be arrested of the cause of the arrest and of the fact that a warrant of arrest had been issued for his arrest. So there are two requirements. Now, you should inform him why he's being arrested and that there is a warrant of arrest for his arrest. But then again, the officer is not required not to present the warrant of arrest before the person to be arrested. It is sufficient that after the arrest, the warrant is shown to him as soon as practicable if the person arrested so requires. Except when, so you are not required to inform him of the cause of his arrest and that a warrant of arrest has been issued for his arrest if the offender flees or the accused flees, or if he forcibly resists before the officer has opportunity to so inform him. Kanang pagkakita pa lang niya sa police officer, nidaga na siya. Or when the giving of such information will imperil the arrest. So kung maghatag kag impormasyon sa iyang arrest, basig di inahinoon ma-execute ang warrant of arrest. The officer need not, sabi ko kanina, hindi siya required na i-present hindi siya required na dala-dala niya yung warrant of arrest at the time of arrest. But dapat, after the arrest, if the person arrested requires the presentation of the warrant of arrest, then he should present it as soon as practicable. What if the arrest is without a warrant of arrest? So meaning to say, this is a warrantless arrest. When making an arrest without a warrant, the officer shall inform the person to be arrested of his authority and the cause of the arrest, unless the latter is either engaged in the commission of an offense, is pursued immediately after its commission, has escaped, flees, or forcibly resists before the officer has opportunity to so inform him, or when the giving of such information will imperil the arrest. Okay, take note. Authority and the cause of the arrest. What if the arrest was made by a private person, or what if the arrest is a citizen's arrest? What is the method? Under Section 9, when making an arrest, a private person shall inform the person to be arrested of the intention to arrest him. So not the authority, because he is not a police officer. So intention to arrest him and the cause of the arrest. Unless the latter is engaged in a commission of an offense, is pursued immediately after its commission, or has escaped, flees, or forcibly resists before the person making the arrest has opportunity to so inform him, or when the giving of such information will imperil the arrest. Ayan, diniscuss ko na din to last meeting. Section 10, the officer has the authority to summon assistance. Ito, discuss na din ito, right to break in or break out of into building or enclosure, or from building or enclosure. Section 13, arrest after escape or rescue. If a person lawfully arrested escapes or is rescued, any person may immediately pursue or retake him without a warrant at any time and in any place within the Philippines. This is one of the exceptions to the rule that an arrest should be with a warrant of arrest. Later, we will discuss the warrantless arrest. But I will just have to discuss, to run through first yung mga provisions that do not need any or any further explanation. Section 14, right of counsel or relative. Any member of the Philippine Bar shall, at the request of the person arrested or of another acting in his behalf, have the right to visit and confer privately with such person in the jail or any other place of custody at any hour of the day or night, subject to reasonable regulations. A relative of the person arrested can also exercise the same right. So, yung person arrested, he can request for his counsel to visit him or his relative. So what are the rights of the person arrested? Number 1, the right to be assisted by counsel at all times. So what is the effect if the person arrested had given a confession without the assistance of his counsel? So we will learn later. The right to remain silent. The right to be informed of the above rights, and the right to be visited by the immediate members of his family, by his counsel, or by any non-governmental organization, national or international. So if the accused or the person arrested is not informed of his rights, or ang tawagan na is Miranda rights, then there is a violation of his rights to due process. Now let's talk about custodial investigation. What is custodial investigation? It includes the practice of issuing an invitation to a person who is investigated in connection with an offense. He is suspected to have committed, without prejudice to the liability of the inviting officer, for any violation of law. So kung mahilig mo tanaw mga salida, kana ganing imbestigahan ka, istoryahon pang tanong ka. So that is custodial investigation. Kana ibutang ka sa room ba? So the penalties for violation of the rights of the person arrested during custodial investigation are provided for under Republic Act 7438. For instance, any arresting officer or investigating officer who fails to inform any person of his rights to remain silent and to counsel. So meron niyang penalty, fine of 6,000 pesos, or a penalty of imprisonment of not less than 8 years but not more than 10 years, or both. Another instance is if any person will obstruct, prevent, or prohibit any lawyer or any member of the immediate family of person arrested, or those who under the law are entitled to visit, shall suffer the penalty of imprisonment of not less than 4 years nor more than 6 years, and a fine of 4,000 pesos. So remember these penalties under Republic Act 7438. So what is the effect if the person arrested will give a confession or testimony without the assistance of his lawyer? So the effect will be, is that any evidence or any testimony given during the custodial investigation without the assistance of counsel will be inadmissible in evidence. Yun siya, inadmissible siya in evidence. So you can object if the testimony or the confession, extrajudicial confession during the custodial investigation is being presented in court as an evidence against the accused. So you can rightfully object because the extrajudicial confession was made without the assistance of the counsel or without a valid waiver, as the case may be. So if there is an extrajudicial confession, that extrajudicial confession should be made in writing and signed by the person detained or under custodial investigation in the presence of his counsel. So dapat nandun ang counsel niya. Kasi isa sa mga rights ng person arrested is that he should be assisted by his counsel at all times. So any confession or testimony made that would incriminate the person arrested will become inadmissible in evidence in court. Or kapag wala yung counsel, there should be a valid waiver. Signed. That waiver must be signed also by the person arrested. And the confession should be in the presence of any of the parents, older brothers, and sisters, his spouse, the municipal mayor, the municipal judge, district school supervisor, or priest or minister of the gospel as chosen by him. Again, if these requirements are not complied with, the extrajudicial confession shall be inadmissible as evidence in any proceeding. So in the absence of a lawyer, no custodial investigation shall be conducted, and the suspected person can only be detained by the investigating officer in accordance with the provisions of Article 125, the Revised Penal Code. If you can recall the provisions of Article 125, the Revised Penal Code, provided therein yung periods within which the person arrested should be held under custody. Beyond that period, the person arrested should be released if there is no complaint, formal complaint filed in court or filed in the fiscal. And the period there depends on the crime, depends on the penalty of the crime or the gravity of the crime committed, alleged to have been committed. So remember that provisions of the Revised Penal Code. Also, any waiver of the provisions of Article 125 shall be in writing and signed by the person arrested, detained, or under custodial investigation in the presence of his counsel. Otherwise, the waiver shall be null and void and of no effect. Basta remember lang na sa lahat ng proceedings before the police officer or the arresting officer, kailangan merong assistance ng counsel. Otherwise, invalid yun siya. And any confession made during that proceeding or investigation will be inadmissible in evidence. Yun lang ang tandaan ninyo. So ito na. Lawful arrest without a warrant. Again, Section 5. A peace officer or a private person may, without a warrant, arrest a person. Letter A, when in his presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. So this is the in flagrante delicto exception. Letter B, when an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it, or the hot pursuit exception. And C, when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment or is temporarily confined while his case is pending, or has escaped or being transferred from one confinement to another. Okay? So in cases falling under paragraph A and B above, the person arrested without a warrant shall be forthwith delivered to the nearest police station or jail and shall be proceeded against in accordance with Section 7 of Rule 112. So hindi kasali yung third kasi we should deliver him to the penal establishment kung saan siya naka-confine before he escaped. Okay, let's discuss them one by one. So again, the general rule is a person cannot be arrested without a warrant of arrest. Then, before a warrant of arrest will be issued, the requisite should be complied with. No? Alam niyo na yon. Under Section 2 of Article 3 of the Bill of Rights. Now, that general rule is subject to exceptions provided under Section 5, Rule 113. So first exception is the in flagrante delicto arrest. So what is in flagrante delicto? It means the person is caught in the act of committing a crime. Kanang in plain view, nakita gid mo siya na nag-commit siya crime. So what are the requisites? The person to be arrested must execute an overt act. Take note of the words overt act, indicating that he has just committed, is actually committing, or is attempting to commit a crime. And such overt act is done in the presence or within the view of the arresting officer or the private person. So, let's talk about existence of an overt act. Kailan mo ba masasabi na there is an overt act para magkaroon ng basis yung police officer or arresting officer or private person to arrest the person committing a crime? So, let us discuss this by discussing cases, no? Cases decided by the Supreme Court. So first, let us discuss People versus Nuevas, GR number 170233, decided on February 22, 2007. Under this case, reliable information alone is not sufficient to justify a warrantless arrest. So let me just give you a background, no, of this case. Ano nangyari dito? Ang nangyari dito is that merong tip, okay? Merong tip sa police officers na may certain person daw, male person, nakalagay sa book, no? Teka muna. Merong male person na parang may drug transaction. And gidescribe nila ang katong male person as 5'4", ang height, and then yung niya itsura, etc. etc. So, kay diri nga lugar daw mahitabo tong drug transaction, drug-related transaction. Ngayon, after receiving the tip or information, the police officers immediately went to the place, to the location, no, described, no, in the information. At while waiting, no, while waiting for the person described, as described, no, by the informant, nasa nakita nga person, male person na nagalakaw. They were thinking na kani siya nga tao is nag-fit siya sa description. Okay? Nag-fit siya sa description sa katong gihatag sa information. So, ilang giduol no niya. Confront nila tapos say about So the allegation of the police officers are that the allegations are voluntarily daw itong si Nuevas, tatlo kasi sila, si Nuevas, si Dina, at saka si Inocencio. Itong si Nuevas yung first nila na in-approach. Nagpakilala silang police officers. Sinabihan nila na, mga police kami. So, in-interview nila si Nuevas, etc. Tapos si Nuevas daw answered arrogantly. Sabi niya, ano ngayon kung police kayo? Sabi niya. Pero later, parang nag-change yung tone niya, nag-speak na siya in waray yata yun na dialect. Parang sabi niya na, sir, nayabuhi lang ako, sir. Kung sabi sa'yo, nayabuhi lang ako, sir. Ana. Tapos, in the hope of escaping liability, sabi niya, napakwiduha ka kauban. Magkita mi karon kay nami transaksyon. Kani si Din o si Inocencio. So, karon nangutana ang police officer, kusa man na imuhang ginagunitan. So karon ingon ingon si Nuevas na, ay kuan sir kanang dara sir pakita niya. Gi-open niya mismo niya, gipakita niya ditong sulod na naisulod nga drugs or sa ganito nga drugs murag marijuana man yata to ana. So and then mo na to gitudlo na niya kung asa dapit sila makita ni Din o ni Inocencio. So, actually, nag-mention pa siya certain Vanji, a woman, no, babae, na siya daw ang mastermind na sa transaction. And now, giato nila tong place or location na kung na-describe ni Nuevas, and they were looking for certain Vanji, tong babae. Tapos, at that time, naapod si Dean ug si Inocencio. So, they saw Dean and Inocencio carrying a plastic bag. So, karon ilang gidakop si Dean ug si Inocencio, napakilala sila nga police officers, etc. And then, yun na. Naaresto na silang tatlo. They were charged. And then, binuksan nila yung cellophane. Tapos, nakita nila doon na may marijuana. So, on that basis, inaresto nila si Nueva, si Dean, at saka si Inocencio. And they were charged for Section 5A of, they were charged for possession of dangerous drugs. So the issue there is that whether or not the warrantless arrest was valid. So the Supreme Court held that yun na nga, reliable information alone is not sufficient to justify a warrantless arrest. First, the court holds that the searches and seizures conducted do not fall under the first exception, warrantless searches incidental to lawful arrests. A search incidental to a lawful arrest is sanctioned by the rules of court. Recent jurisprudence holds that the arrest must precede the search. The process cannot be reversed, as in this case where the search preceded the arrest. Nevertheless, a search substantially contemporaneous with an arrest can precede the arrest if the police have probable cause to make the arrest at the outset of the search. Okay, in the case, Nuevas, Dean, and Inocencio were not committing a crime in the presence of the police officers. So let us review the facts that I have discussed to you. With respect to Nuevas, yung palakad-lakad lang siya sa kalsada, wala naman siya ginagawang masama. Tapos, pinuntahan siya ng mga police officer, inaresto siya. Sabi ng law, there is no overt act. Sabi ng court, walang overt act doon. Wala naman siyang crime na kinumit by simply walking on the street, di ba? Carrying a plastic bag. Ayan. So, therefore, that arrest is not valid. With respect to Dean and Inocencio, the same ruling was made by the Supreme Court. Yung palakad-lakad lang silang dalawa, and then nagsanay sila, nadala sila cellophane, dili daw to siya basis for the arrest of these persons because there is no overt act. They are not committing a crime. So kung naglakaw-lakaw lang ka sa kalsada, bisan pang nagdala kag marijuana diha, for as long as yung marijuana, wala gyud siya nakit-an in plain view, kay nakasulod mo sa cellophane niya, nakabalot pa gyud siya og newspaper, so there is no overt act. That would be the basis for the police officer to arrest these persons, sabi ng Supreme Court. Okay? Moreover, police officers Fami and Kabling did not have personal knowledge of the facts indicating that the persons to be arrested had committed an offense. The searches conducted on the plastic bag then cannot be said to be merely incidental to a lawful arrest. Kasi sabi ng, hindi pa kasi tayo nag-discuss ng search and seizures, but under the law kasi, in this case, nag-enumerate ang Supreme Court ng mga instances wherein you can validly search a person. And one of the instances is a search incidental to a lawful arrest. So if the arrest is lawful, you can validly search thereafter. So in this case, what the police officers did is that they searched first the plastic bag before they arrested these persons. On the basis of finding a marijuana on the plastic bag. So sabi ng Supreme Court, that is not valid kasi naging reverse. Dapat may lawful arrest muna bago ka nag-search. Since yung arrest naman, hindi lawful kasi wala nang basis, kasi walang overt act para maging basis for the arrest. So the rule requires, in addition, that the accused perform some overt act that would indicate that he has committed, is actually committing, or is attempting to commit an offense. So again, dito sa case na ito, Nuevas din and Inocencio are merely walking by the street, no? When the police officers have approached them or have seen them. And meron pa pala. Secondly, neither could the searches be justified under the plain view doctrine. An object is in plain view if it is plainly exposed to sight. O ayan, di ba sabi ko, gawas na lang kung katong cellophane, transparent kay to siya. Unya, sa ka-transparent niya, maklaro sa police officer nga drugs gito. Murag na sila probable cause to believe that the contents of the plastic bag are drugs or drug paraphernalia, whatever, no, kung transparent lang siya. Pero in this case, manggod, the marijuana were wrapped, ayan, nakalagay dyan, were wrapped inside a blue cloth. So there is no way for the police officers to identify or to determine with such certainty na ang sulod day sa plastic bag are dried marijuana leaves. Diba? So there is no reason for the search. So other cases, no, involving the existence of an overt act are People versus Aminuddin. Here, there is non-compliance of the in flagranto exception because the person arrested here was merely descending the gangplank of the ship and there was no outward indication that called for his arrest. Nimbaba lang siya sa kuan ba sa ship, kanang gangplank sa ship, nag-descend lang siya niya, gidakop na din siya. Pero there is an information here. The Supreme Court found non-compliance of the in flagrante delicto exception here because actually ang nangyari dito, 2 days before the arrest, nakatanggap sila ng information. Sabi ng Supreme Court, you have enough time to secure a warrant of arrest. So therefore, there is no reason for you to conduct a warrantless arrest because the information was received 2 days ago, sabi ng Supreme Court. And secondly, walang ibang barko daw na darating during that period. Ito lang na ship, sabi ng Supreme Court. So certain kayo. So therefore, you should have secured a warrant of arrest. Ayan, basahin nyo yan. So, the court declared as inadmissible in evidence the marijuana found the possession of the accused as a product of an illegal search since it was not an incident to a lawful arrest. So, walang overt act, sabi ng Supreme Court. Wala namang sinasabi sa batas na kapag mag-descend ka or maglakad ka sa street, may criminal offense ka na, di ba? So there is no overt act. In People versus Molina, the accused was arrested while inside a pedicab despite the absence of any outward indications of a crime being committed. Nagsakay lang siya pedicab, gidakop na siya. So dili gihapon. So sala na dahil ni karon nang nagsakay og pedicab. Sabi ng Supreme Court, di ba, if you will, mag-analyze lang yung problem ba. Malacat versus CA, 283-159, the eyes of the person arrested were moving fast and looking at every person passing by. Sabi ng mga police officers dito, suspicious daw kaayo sila kay pastos o kay muliho kay ang mata niya. Sige daw tanaw, di ba? At every person passing by. So, kung yun na di ay kanang nakulbaan lang kanya, tungod sa imong kulba, nagpaspas og lihok imong mga mata, ana tanaw ka sa mga kuan, nakasala na day ka ana. Ang Supreme Court. So there is no overt act, sabi ng Supreme Court. Kani si People versus Mingote. Katong murag ano man yata ni siya, kanang checkpoint man yata ni si Mingote. Ay, dili ni siya checkpoint. In the street corner in Tondo, no? So, again, there is an information lang, no, that certain person will commit a crime, no, in a street, no, at a street corner in Tondo. So, Mengote was looking from side to side, clutching his abdomen. So, ingon ang pulis na suspicious daw kaayo siya. So, gidakop siya. But the Supreme Court held that there was no offense which could have been suggested by the acts of Mingote of looking from side to side while holding his abdomen. Observed the court, these are certainly not sinister acts. He was not skulking in the shadows but walking the clear light of day. There was nothing clandestine about his being on the street at that busy hour in the blaze of the noonday sun. By no stretch of the imagination could it have been inferred from these acts that an offense has just been committed or was at least being attempted in their presence. So, Supreme Court said that there is no overt act so as to validly arrest the person arrested. Okay? Wala daw overt act. Ayan, read the case of People versus Claudio, Tangliben, and Maspil. But take note here in these cases, the Supreme Court here found existence of an overt act. So let's start with People versus Claudio. Ito yung babae carrying a woven buoy-like plastic bag which appeared to contain kamote tops, boarded a bus bound for the province. Instead of placing the bag by her side, which is the usual practice of a traveler, she placed the same on the back seat where a trained anti-narcotics agent was seated. So, based on probable cause, the said agent had suspicion that the contents of the buoy-like plastic bag are marijuana. So, mo na to nga iyahang the agent inserted his finger inside the bag where he felt another plastic bag in the bottom from which emanated the smell of marijuana. So the Supreme Court here upheld the arrest of that woman. So merong overt act. So People versus Tangliben, ito. Two police officers together with a barangay tanod were conducting surveillance operations in a bus station allegedly to check on persons who may be engaging in the traffic of dangerous drugs based on information supplied by informers. So they noticed a person carrying a red traveling bag who was acting suspiciously. When asked to open the bag, the accused did so only after the officers identified themselves. Found in the bag were marijuana leaves wrapped in plastic and weighing about 1 kilogram. Upon these facts, it was ruled that there was a valid warrantless arrest and a valid warrantless search. The court pronounced Tangliben to be different from Aminuddin. Ano nga ulit yung ka-Aminuddin na case? Yung descending the gangplank of the ship. So dito, sabi ng Supreme Court, here daw in the case of Tangliben, the court found that the officers were faced by an on-the-spot information which required them to act swiftly. Diba? Unlike in Amino din, merong 2 days pa. 2 days pa ang nilabay before sila nag-aresto. But here in Tangliben, kadyot lang kayo, no? Naghatag information, diya dayon. Nag-aresto sila. Nag-conduct dahin sila surveillance operations. So, mo na nga, lahi ang Tangliben o ang Amino din. There is sense of urgency. Ito, People versus Maspil. Checkpoint. Ayan. So, sa checkpoint. To monitor, inspect, and scrutinize vehicles bound for Baguio City. A couple of hours after midnight, a jeepney was flagged down in the checkpoint. On board were the persons identified by the informers who were also with the policemen manning the checkpoint. Ay, teka muna. Kindly research the recent case na decided by the Supreme Court with respect to search of moving vehicles. I think merong bagong interpretation yung Supreme Court, reversing or overturning their previous decisions on the matter. So, kindly search that case. Ano nga yun na case? Research ko man yun kanina. But I forgot the name of the case. But it was decided on June 16, 2020. Ayan. Merong bagong decision yung Supreme Court. So let's proceed to hot pursuit exception. When an offense has just been committed and he has probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Yeah. So, what are the requisites for hot pursuit exception? Number 1, an offense has just been committed. Second, the person making the arrest has personal knowledge of facts indicating that the person to be arrested has committed it. But take note that this exception does not require the arresting officer to personally witness the commission of the offense. Otherwise, it will not be considered as a hot pursuit exception. Instead, it will be an in flagrante delicto arrest. If the offense was committed in his presence, so hindi na siya hot pursuit, in flagrante na siya. What is required here is that there should be probable cause to believe, based on personal knowledge of facts or circumstances, that the person to be arrested has committed it. Examples are in the case of Abilita III versus Doria. Ano nangyari dito? Okay, the police officer here received a phone call about a shooting incident. So meaning to say, the police officer here did not witness the commission of the offense. So after receiving the phone call, immediately thereafter, a team was dispatched to investigate. The investigation disclosed that the victim was wounded, and the witnesses tagged the petitioner as the one involved and that he had just left the scene of the crime. So after tracking down the petitioner, he was invited to the police headquarters, but the petitioner, who initially agreed, sped off, prompting the authorities to give chase. So, from these facts and circumstances, there exists probable cause to believe that the person sought to be arrested has committed the crime. So, the Supreme Court upheld the warrantless arrest because there exists probable cause. So ito, Two robbers, in the case of People versus Akol, two robbers divested the passengers of a jeepney of their belongings, including the jacket of one passenger. The passengers immediately sought the help of police officers, which formed a team to track down the suspects. One of the passengers who went with the responding police officers saw one of the robbers casually walking the same vicinity and wearing his jacket. So the warrantless arrest of the accused was sustained by the court as well within the hot pursuit exception. So I think the police officer here, the arresting officer, or the private person, as the case may be, should have a parang connecting a link. Kasi hindi niya na-witness yung commission of the offense. So therefore, he should find a link para makonect niya yung crime, yung commission of the crime, and makonect niya yun sa person sought to be arrested. So, example dyan is, may nakakita, merong witness, or the victim himself. So the basis of the arrest will come from the person or the victim who has seen or the victim mismo, di ba? He experienced the against whom, di ba, yung crime na commit. So I think that should be the case, if the arrest is through a hot pursuit exception. Dapat yung police officer should find a link para ma-arrest niya yung person for the crime that has just been committed. So an example is that dapat merong witness na nakakita or yung victim mismo, yung tumawag ng rescue or ng mga police officers. And dapat there must be a sense of urgency. Meaning to say, after the phone call or after the report, the police officer should immediately go to the crime scene para ma-justify ang hot pursuit arrest. Otherwise, if the police officer will not immediately respond to the call of the victim or any witnesses, then basig mapaso ang hot pursuit arrest. So dili na justified ang hot pursuit arrest kung dugayon sa police officer. Kasi the reason behind this principle allowing arrest without a warrant in a hot pursuit exception is that urgent ang pag-aresto sa akusado. So kung dili, wala na siya sense of urgency, therefore may yun ang Supreme Court na wala man di ka nagdali. So pagkuha na lang sa dito warrant of arrest. So that is the reason why an arrest is allowed in a hot pursuit exception. Kasi ginagukod pa man nimo akusado, alangan naman, di ba? Para ma-aresto na dayon nimo siya, there is no need to secure a warrant of arrest. Sabi ng Supreme Court. Kasi merong sense of urgency. Pero kung wala na yung sense of urgency, then that's the time that you should secure a warrant of arrest because you can no longer use this hot pursuit exception kasi wala nang sense of urgency. Naglabay naman ng time. O gaya ng in flagrante delicto arrest kanina, di ba? 2 days before pa yung arrest, na-receive nila yung information. So why is it na hindi sila kumuha ng warrant of arrest when they have 2 days to secure the warrant of arrest from the court? So wala na yung sense of urgency kasi after 2 days pa sila nag-conduct ng arrest. So that is the essence no of warrantless arrest. Para madakpan na yun kung kisa man itong nag-commit of crime. In People versus Gerente, the Valenzuela police station received a report of a mauling incident which resulted in the death of the victim who received a massive skull fracture caused by a hard and heavy object. Right away, ayan, di ba? Take note of these facts no, and circumstances. Right away, the officers went to the crime scene and found a piece of wood with blood stains, a hollow block, and two pouches of marijuana. A witness told the police that the accused was one of those who killed the victim. They proceeded to the house of the accused and arrested him. The court ruled that based on their knowledge of the circumstances of the death of the victim and the report of an eyewitness, in arresting the accused, the officers had personal knowledge of facts leading them to believe that it was the accused who was one of the perpetrators of the crime. Ayan. Yan yung sinasabi ko na para ma-establish mo yung probable cause na yung person talaga na aarestuhin nyo is the person who has committed the crime, na kakakumit lang na crime, there should be a link. And that link is the victim himself, kung buhi pa siya, di ba, niya, nakareport din siya, or any eyewitness. Otherwise, in the absence of this link, you cannot establish, no, the police officer cannot establish probable cause. Ano yung basis mo? Di ba? Ano ngayon yung basis mo para hulihin siya? Unless na lang kung nakadungog ka, kato kung example last meeting na nakadungog ka og syagit, nga, ang syagit dira lang gid sa imuhang press, sa imuhang kuan ba, duol lang kay sa imuha, although wala nimo nakita ang commission sa offense, pero nakadungog ka og syagit, ni-respond dayon ka kay natud-an nimo ang location, then you saw a person running from the crime scene. So that is enough no to establish probable cause. But if wala ka nakadungog, naa ka sa police station and the crime was committed in a different location, or doon sa inyo ha, pero wala gyud ka kadungog, dapat naay mo witness ana, dili pwede nga naay namatay dito, then pagkahuman niuli ka police officer, pag uli nimo nakita nimo nga naay namatay, tapos wala, kung saan mo pagkabalo, kinsay dakpo nimo nga wala may naka-witness, ikaw ra may nakakita. Tapos pagkakita pag yun nimo, patay naman dito, wala naman po ilaing tao. So, there is no probable cause no to arrest any person kay wala may mo witness, di ba? So, muna akong pasabot no. That is what I'm telling you na there should be a link, a witness or the complainant himself or the victim himself in order to establish probable cause. Ay, kadali lang, nabe. Kapit na, mano lang nako. Waiver of illegality of arrest in People versus Aminola, GR number 178062, decided on September 8, 2010. A warrantless arrest is not a jurisdictional defect, and any objection to it is waived when the person arrested submits to arraignment without any objection. Okay? The fact na yung arrest is warrantless does not affect the jurisdiction of the court. Okay? So, if you wanted to question the validity of your arrest without a warrant, you should raise that objection before you enter your plea or before arraignment. Otherwise, if you have already plead guilty or not guilty, then you have deemed to have waived your right not to question the validity of your arrest. So, na-cure to siya tong illegality of the arrest if that is the case, no? Let me just discuss, no? Persons not subject to arrest. Ayan, pag-usapan muna natin tong waiver, no, of illegality of arrest. So how will you question, how will you object now the illegality of your arrest? So you can object it by filing a motion to quash the warrant of arrest before arraignment. Because if you will belatedly raise that raise that issue on appeal or even during the trial of the case, then that will not be entertained by the court, because you have deemed to have waived your right to question the legality of your arrest after entering your plea of not guilty. So let's go to the next topic, persons not subject to arrest. Ayan, mga immune. And alam nyo na yung Section 11, Article 6 of the 1987 Constitution. A senator or member of the House of Representatives shall, in all offenses punishable by not more than 6 years imprisonment, be privileged from arrest while the Congress is in session. So take note of the range of the penalty. It should be not more than 6 years. So if the penalty is more than 6 years, even if the Congress is in session, then that senator or member of the House of Representatives can still be arrested. And even if the offense is less than 6 years, but if the Congress is not in session, then the senator or member of the House of Representatives can be validly arrested. So under international law, sovereigns and other chiefs of state, ambassadors, ministers plenipotentiary, ministers resident charge the affairs cannot be arrested. They are immune from arrest. And under Republic Act 75, bawal din arestuhin yung duly accredited ambassadors, public ministers of foreign country, their duly registered domestics, yung mga katulong nila, for as long as they are duly registered. But take note, this is subject to the principle of reciprocity. And what does that mean? It means that yung country, yung foreign country na nag-send ng mga ambassador dito sa Pilipinas should also provide immunity for Filipino ambassadors in their country. Yan yung ibig sabihin niyan. Dapat merong reciprocity agreement, no? Otherwise, pwedeng arestuhin kung walang reciprocity. Okay, that ends our discussion for Rule 113, arrest. So we will continue now with our discussion, Rule 114, next meeting.